She got bored.
Hello, good evening, everyone. It is right at 7 o'clock Eastern, 6 o'clock Central, so I will just give a couple of minutes, not too much time, because I know today we will probably have the full hour for today's presentation. So stand by, we'll just give a couple more minutes before we get started. Okay, I think we are just about ready to get started. So hello, good evening, salam. Thank you all so much for joining the Muslim Legal Fund of America, MLFA, for part 2 of our 4-part webinar series related to Muslim nonprofits. Today, we're going to be diving into the legal landscape shaped by 18 U.S. Code Section 2339B, a key provision of the Antiterrorism and Effective Death Penalty Act. This statute has significant implications, not only for individuals, but also for our Muslim nonprofit community and organizations engaging in international humanitarian and advocacy work. I am Sana Salim, MLFA's Nonprofit Governance Department Manager and Staff Attorney, and we'll get right into today's topic. But first, I want to just share a little bit about MLFA. It's a community-centric grassroots nonprofit organization fighting for national security reform and upholding and establishing justice in our courtrooms and communities for Muslims in America. We are uniquely positioned in that we have 4 legal departments in-house at MLFA, all pro bono. We have our Federal Criminal Defense Department, Civil Litigation, Immigration, and our Nonprofit Governance Department. If you or anyone you know needs help in these areas, please go to our website and fill out an intake form. We also have an events page where we keep you updated with webinars like these, any other Know Your Rights programs, legal clinics, anything else going on at MLFA. And also, you can follow us on Instagram at Muslim Legal Fund. We'll put that link in the chat box as well. So I am thrilled to introduce to you our speakers today. Charlie Swift and Sophia Khalid are on the screen with us. Charlie is the head of the National Security Criminal Defense Center. I misspoke earlier and called it the Federal Criminal Defense Department. It is the National Security Criminal Defense Center. He is known for winning the U.S. Supreme Court case of Hamdan versus Rumsfeld and is a nationally recognized national security expert. Just like last time, I could go on and on about his accolades, but I'll let you all read the rest of his bio online. Sophia is our senior staff attorney in our National Security Criminal Defense Center. She's been with MLFA since 2019 and works on both trial and appellate federal court cases involving entrapment, material support, and so much more. We'll also have Huma and myself, who are our nonprofit governance attorneys, join later in the presentation to field any questions surrounding governance and compliance and things like that. As a reminder, please keep all of your questions pretty general in nature. Don't reveal anything confidential or fact specific to your organization. If you have questions, again, feel free to fill out that intake form. I believe our email addresses should be on the last couple of slides as well. If you just want to email us questions, we're happy to field those questions as well. So without further ado, I will turn it over to Charlie and Sophia to get started on today's presentation. Thank you.
Okay, next slide. We can have. Okay, my name's Charlie Swift, and I, along with Sophia, are going to be talking to you. And what's the purpose of what we're doing? Well, our purpose is educational. We want to educate you on the law and some of its practical applications and how you can do it. What that means is that the information is generalized. It's not specific to your organization. It's also a public presentation. That means anything you say is not protected by the attorney-client privilege. This is not a privileged conversation, so everything should be generalized. Finally, it's not legal advice on any particular situation. Every situation, even if it seems exactly like something we put into this to you that's in this presentation, has additional facts that have to be considered. So please don't take this as legal advice, though we give a lot of legal advice. We do that on an individual part on it. And what we're going to talk about here is that our presentation here is based on the work that we have done supporting the nonprofit division, some of our own cases, our experience with clients, all of those areas. And that's how we've gotten the ability in studying the law to talk about what we're going to talk about. Now, there are a lot of overlapping issues that have come up in these parts and and we have many requests for assistance. Can we have the next slide? In this, at the center of almost every piece of advice is what Sana said, 18 U.S.C. 2339B, the Material Support of Terrorism statute. And it has particularly relevance right now to Gaza and to other areas in the Middle East. But we're talking particularly Gaza-centric today. But it's not the only law. There are sanction schemes for Gaza under AEDPA. There are also related charges in wire fraud and obstruction of justice. So this statute sits at the center. We'll be referencing some of these others, and we talked about the AEDPA sanctions in a different presentation at length, but it's important to understand that there are multiple criminal statutes, but we are focusing on the central one that centers at every investigation that the government can conduct. Sophia, can you tell us about the agenda? Take us through that agenda today.
Yeah, so we've got a lot to get through. We're going to start by talking about the current context, so the current climate with all of these new congressional investigations, Gaza, what's happening with DOJ. Then we'll go specifically into the congressional investigations and talk a little bit about that. We've been getting a lot of requests from nonprofits about those. Next, we'll focus on specifically material support law. So what is that statute? How has it been interpreted? What qualifies as material support? Then we'll touch on sort of the overlapping criminal-related concerns that Charlie just mentioned and how they all relate together in these cases. We'll talk about some specific recent material support cases and entrapment issues and what sort of the most recent material support framework and counterterrorism investigation practices have looked like. Then we're going to do more of a deep dive on the Holy Land Foundation case. That's one of the largest cases in material support, specifically a nonprofit that was prosecuted, and touch on some of the more historical approach to material support. Then we're going to wrap up with talking about applying all of that to now, right, for individuals and nonprofits now, discussing sort of the risk tolerance with political speech and humanitarian aid for different individuals and organizations. And we'll end with what nonprofits can do to address a lot of the concerns that we will talk about today. Let's start with the current context for our discussion about material support. This, all of these atrocities happening in Gaza over the last almost 2 years, it feels like, have resulted in a lot of political and religious speech, humanitarian aid efforts. There's been this massive increase in activity and speech related to Gaza. And we're focusing on Gaza today when we're talking about material support and sanctions, but everything because of the current events. But the material support statute and other criminal statutes that we're talking about apply to other regions as well that have designated foreign terrorist organizations or sanctions, places like Iran, groups like Hezbollah, ISIS, Al-Qaeda. Everything we're talking about today, we'll be discussing in the context of Gaza, but it applies more broadly. And we're focusing on Gaza today because the new administration has put a significant focus on investigating efforts by nonprofits and individuals that are working to ease the humanitarian crisis. And they are scrutinizing these efforts as possible terrorist financing, essentially. This effort was outlined in a recent executive order. And that new order was outlined a new focus for the Department of Justice. The National Security Division at the Department of Justice, which is where all the material support cases and terrorism-related charges come out of, has created a new task force called the October 7th Task Force. And in announcing that, they announced that some of their focus for US-based individuals will be individuals and entities that they believe are providing funding to Hamas. And they will be investigating and prosecuting individuals and organizations they believe are responsible for funding Hamas. In that order, what we can tell from it is who they've staffed it with. They've staffed it with money laundering prosecutors from their criminal division, for forensic accountants, data scientists, talking specifically about terrorism financing in that discussion. And so all of this suggests a focus from the Department of Justice now on organizations, most likely nonprofits from what we have seen, in investigating them for terrorist financing, funding of Hamas and other Palestinian designated organizations or related organizations. At the same time, there's been a sharp rise in a focus on Iranian-backed organizations. So the sanctions, export controls, tariffs, import restrictions, all of these restrictions on Iran, there's been a rise in using that framework that we'll touch on a little bit later, and focusing on the Iran-backed groups. So the Houthis, Hamas, Hezbollah, designated foreign terrorist organizations, and other sanctioned individuals that are sanctioned under the OFAC scheme. And we've seen an increase in those targeting. We expect to see an increase in investigations related to anti-money laundering and sanctions. And that is because this is of particular concern to us because this did not exist before. And in this highly politicized climate, there is room for a lot of abuse of this new system. But basically, OFAC, the Office of Foreign Assets Control, used to be the only body out of the Treasury Department that was enforcing a lot of these sanctions, the sanctions regime. They've expanded now to FinCEN. FinCEN is becoming increasingly active on these issues, and one thing that they have recently created is this new anti-money laundering and sanctions whistleblower program. And what that allows is for individuals to essentially make a complaint, provide a tip to this whistleblower program, and awards are paid out for successful enforcement actions that come out of those tips. And so in this politicized climate, there is now a way for members of the public, political actors, to provide tips, complaints against nonprofits, political organizations, other things, to this other, enforcement body. And there's this award scheme that is going to promote that. Charlie, can you talk about the increase in the focus of current congressional investigations now into nonprofits?
I certainly can. What we know is that the also increasing our congressional investigations. I call this the flip. Following one outgoing political organization, it now seems to be one of the unfortunate byproducts of the Jan 6 investigations is now, okay, when I take power, when the Trump administration took power, let's investigate everybody we consider to be opponents. And where one of those areas, they have been investigating significantly immigration rights groups, people who enforced anti-discrimination laws, foreign influences, et cetera, foreign gifts, et cetera, and abuses of power and fraud. So, all the things that you heard in the speech that they were angry about. But anti-terrorism laws, i.e. alleged ties with terrorism, particularly since Gaza's begun, ties to Hamas, has been a significant area in part. And can I get the next slide? I'm sorry. What we see on this is that 19% are pro-Palestinian organizations of the 200 letters that went out to start congressional investigations. So everybody's getting calls. So it's worth talking about, why a congressional investigation? What are they investigating? And what are my rights here? Next slide. So why? Well, there's a lot of ways to investigate things. The classic investigation is conducted by the FBI. That would be conducted under the task force that Sophia just talked about. But it's still, they may create a task force, but the FBI guidance and part requires some level of probable cause to begin the investigation of any particular organization to avoid political targeting. And if they want to get documents, if they want to get testimony, or they want to search the place, they're going to have a judicial finding of probable cause at some time. In other words, it's not a fishing expedition. Now, something that we saw all during Syria and Yemen was grand jury investigations. We don't talk about our clients, but trust me, there were several, more than several. Grand jury investigations launched into organizations. A grand jury does not require probable cause. You would think it does, but a grand jury investigation doesn't. They simply open one. However, you don't know about them because they're secret. I can't talk about them. The people under investigation certainly don't talk about them, and the government can't talk about them. So they're secret investigations, and that doesn't play well politically. Congressional investigations are popular because they require neither probable cause nor is it secret. In fact, we saw the Jan 6 kick off with congressional investigations when DOJ drug its feet. So what we're seeing is a repeat in this, is that they're using congressional investigations because they get C-SPAN and it gets an audience and an opportunity to make speeches. And we're also seeing that, there was a bill that's been talked about a great deal that was going to designate, make it much easier to strip nonprofits based on their quote unquote material support of terrorism. They're going to strip them down, either at Treasury or now at the Secretary of Defense level. That bill it was passed in the House. It was pulled out by the parliamentarian. The House dropped it when they realized that the parliamentarian was going to remove it from the Senate legislature on the one big, beautiful bill. And it's still out there. It's still a major concern, but this is a way to spur that on. So they're going to be looking at organizations in this. And I need, next slide, please. Can we get the next slide, please? Okay, we do. Okay. It's well understood that the Supreme Court's confirmed. Congress has the power to conduct investigations with limitations, including subject to protection of individual constitutional rights. So, and there's a whole part on this stuff that you can start with. Does anybody actually have to testify? Do they actually have to? There is some areas where individuals can invoke the Fifth. Organizations, it's a little more difficult. Most investigations, however, start voluntarily. You receive a letter and they ask you, would you be willing to participate in an interview, provide materials, etc., sit for a deposition, respond to interrogatories, etc. Now, those are difficult questions. And the first part I'm going to hit on this is that's organizational specific, but no organization should make these decisions without having an attorney assist them who has experience in congressional investigations and understands the organization and what these guys are looking for. because, and not participating may lead to compulsory investigations where the committee issues a subpoena. And as some of the case law during the Jan 6 held out, not showing up for the subpoena is a misdemeanor. You can go to jail. You have to produce the records, et cetera, on that. But again, you should have an attorney absolutely advising you in these matters. It's serious. And also, sometimes things are counterintuitive. An example I'll give from recent parts is a lot of organizations have document retention policies, and Sophia's going to talk about them. So organizations who look up, well, wow, we saved a lot of stuff we didn't have to save. Let's get rid of it. That would be a bad idea right now, because there's another law, obstruction of justice. And it came out 18 USC 1509, which is the Enron statute, that if it makes it difficult to say, hey, I didn't get rid of those documents because I thought they were going to be subpoenaed or might be part of an investigation, because that's exactly what Enron and Arthur Andersen did. So they passed a law to prevent it in the future. And, you don't want to set yourself up on that. So if you're concerned about an investigation, you're a target of an investigation, you need an attorney to help you get ready and to advise you on what your best courses of action are. So Sophia, let's talk about what they're going to investigate.
Right. So this is where we've been hearing a lot about material support, and what we want to focus on in talking about what does that mean practically in terms of the law and how it applies to organizations and individuals. There are several material support statutes. The one we're talking largely about today is 18 USC 2339B, which prohibits anyone from knowingly providing material support or resources to a foreign terrorist organization or attempts or conspires to do so. There are other material support statutes that prohibit concealing sending finances to a terrorist organization and prohibit providing material support to terrorists. So that can be anyone engaged in these sort of unlawful terrorist activities on the ground that are not necessarily tied to a foreign terrorist organization. Today we're focusing on material support under 2339B. So what are these foreign terrorist organizations? There are several U.S. designated foreign terrorist organizations. In Gaza, there is Hamas, which has several other associated aliases and names. So there's Al-Qassam brigades and several other associated battalions and groups. There's the PFLP, the Palestinian Islamic Jihad. Then there are related groups, right? Hezbollah, and now I've seen recent news reports talking about ISIS-backed gangs in Gaza, which raises all sorts of concerns because that has been their sort of go-to organization for a long time. So now that there are reports of them being in Gaza, that raises additional concerns. Providing support, material support to any of these organizations is prohibited under that statute. That includes members of the organizations, benefiting the organization, working in direction and coordination with them. So let's go to our next slide. A lot of the focus and questions we've been getting recently is, can your speech be considered material support? And there was a Supreme Court case in 2010, Holder versus the Humanitarian Law Project. That case considered this question. And essentially what they laid out, they left, certain questions unanswered, but they laid out that speech provided at the direction of or in coordination with a terrorist organization to benefit them is prohibited. The only speech that is not prohibited is independent advocacy. Independent advocacy has to be speech that is not provided in direction or coordination with the terrorist organization. That can look like acting as a spokesperson, being in contact with members of an organization and acting on their behalf of things that they've interpreting this particular case have been, for example, public calls posted by ISIS, an ISIS commander, for attacks and individuals sharing that were acting in response to it. So independent, I'll talk more about speech on the next slide. It's not just money. You can go to the next slide, Senna. All right. A lot of people, a lot of organizations that we've spoken to, because in certain contexts and up to a certain point, the focus for material support was on material support as funds. And certainly when we're talking about the sanctions context, it is only, financial and monetary support. But in the material support criminal context, material support has been interpreted pretty broadly. It includes services and different types of speech. For example, from some cases, sending money to aid organizations, even if it's for purely humanitarian aid, that has been considered with their families. Giving someone's contact information has been charged as providing or attempting to provide material support. So that was providing a telegram handle to somebody else that the individual believed was either going to join or for the benefit of a terrorist organization. That has been charged as material support. Actually joining an organization or helping someone else to join, even if that is just talking about travel plans or how to hide travel, that has been charged. Speech with or at the direction of an FTO has been charged. Another type of case I'm thinking of is where someone acted as a spokesperson. So they were writing media articles and things to publish online for that organization. That has been charged as material support. Sharing a link to a website in a case that we had that Charlie will talk about. Providing material support isn't the only way material support is criminalized. Let's go to the next slide. The speech concerns. So if you'll remember on the initial slide about material support, it was criminalizing material support, but also an attempt or conspiracy to provide material support. And so this is where we've seen the bulk of material support cases. And that is, for an attempt, for example, that has been cases where they have discussed the possibility of providing some type of support, even if it's just humanitarian aid or a charitable donation that would knowingly benefit a foreign terrorist organization or one of its members, and then taking any substantial step. So that could be buying a ticket, sending a website link. These things have been charged as attempted material support. Attempt or conspiracy to provide material support carries the same 20-year maximum sentencing implication as actually providing it. Conspiracy. A lot of the criminal charges also include conspiracy, and that is when two or more people conspire to commit the offense, and anyone involved do an act to advance the conspiracy. An act to advance is less than a substantial step. And what we see in a lot of these cases is, both for attempts and conspiracies, is that there are often multiple FBI undercovers, informants that are involved, often in group chat situations. I have speech on this slide because a lot of these charges now arise from speech and online activities. So things happening in encrypted chats and other chat rooms online, a lot of religious speech tied in with political speech in there, and where you can have informants, and in cases that we'll talk about, give some specific examples of. But Charlie, is material support the only thing they can prosecute in these types of lengthy investigations?
No. Well, you mentioned OFAC, which is the Office of Foreign Assets Control. And this is the area that changes fast on the ground, and it's especially with what's happening with Iran, moving in very quickly. These are OFAC has controls on just generally any level of trade. They can, where material support requires a designated organization, the 2339B, OFAC requires merely, it doesn't require a finding of fact, doesn't require any of that. There has to be an executive order invoking AEDPA. And can we, and AEDPA as it relates to Gaza, I'm going to talk about that now. Can we take a look at the AEDPA slide, please? AEDPA serves as the legislative authority for Treasury sanctions, the president actually, but Treasury is who issues the parts on it. AEDPA is the International Economic Emergency Powers Act. You hear all about it. We did an entire thing on it. But AEDPA also allows that under the existing part for OFAC to put out specific sanctions of individuals. So in Gaza, there is Hamas, and then there are tons of people who either because they're believed to be associated or some part to Hamas or with any of the organizations are separately under OFAC sanctions. And that OFAC list, it's a different statute, but again, it's 20 years because it's the same statute ultimately comes back on it. Often too, because it's very difficult, banks won't send to it. One of the most commonly charged parts are anti-money laundering statutes and or wire fraud, because people, they may not even know they're on the OFAC list, but they try and get around it by sending money through some other means. And when you use the wires to circumvent a regulation, that's money fraud, that's money laundering. And when you make a representation as to who it's going to and it's not going to, that's wire fraud. Next slide, please. All
right. So back to material support. So as like Charlie's talking about, there are a lot of overlapping concerns here. And that's because when they start a federal criminal investigation, it may start as an interest in material support, and then all of these other implications come into play. Looking at these prior material support cases, the most recent ones that have been happening up until, Gaza and everything that's been happening with Gaza, there's been a lot of entrapment that we've seen. A lot of the material support cases have been the result of these targeted sting operations that involve the informants and undercovers that I had talked about. And it is concerning. It is alarming. We have only seen an increase in of those use of those tactics. And that's because it's very difficult to prove the defense of entrapment. The reasoning for that is that entrapment requires proving that both there was government inducement, that the government was the one sort of egging on the offense and pushing this political and religious speech to cross the line, proving that, but also proving that the individual that is charged, the defendant, was not predisposed. And a lot of evidence that is used to show that they were predisposed has been political or religious speech. So, for example, liking posts by the designated foreign terrorist organization, retweeting those posts, those things have been used to show that that individual was predisposed, and has worked in courts all across the country to justify the investigation and negate any success of the entrapment defense. This is all particularly concerning because online people speak differently, especially young people. Everyone, most people are less inhibited online. People are significantly less inhibited in these encrypted chats where they feel like there is this extreme sense of privacy, and so they're looser with their speech. They're much more emotional, and there's hyperbole, passionate language. And if you combine that, unfortunately, a lot of what we've seen in these investigations is targeting of vulnerable people, of people with mental health issues, new people to the community that may not be so familiar with the issues and the legal implications of certain types of speech. And this is all relevant to organizations now, because these are individuals that may be in your organization. They may be on your board. They may be your partners. And their speech and these investigative tactics that could be targeting them could seriously implicate and have serious implications for you and your organization. And so being aware of them, understanding how they work, and educating the members in your organization about this is really important. One of our cases that exemplifies some of the issues we've encountered with these counterterrorism investigations is that of Georgiana Giampetro. Georgiana's case stands out for a few reasons. She was an individual, she was a new convert, really smart woman, sort of hard on her sleeve, humanitarian type. She was a clinical social worker. And she was very impassioned and, sort of was looking at a lot of the images of what was happening in Syria and the children. And she was talking to a lot of people online. This included undercover FBI agents who began targeting her with some very, a lot of religious speech, and that stood out to us because they were using a fake Saudi sheikh, a fake religious leader that they approached her with, who gave her deliberate misinterpretations of Quran and Hadith and encouraged her that if she really cared about this and she wanted to, do the right thing Islamically, that she should be traveling and making hijrah. And she was able to argue back, on some of these deliberate misinterpretations, but they kept pushing that. And a lot of this sort of religious propaganda and online radicalization was coming from the FBI. And so, and it had an impact on her. Her close friend, who she eventually was charged with, she was the one who provided that Telegram handle to her friend that they eventually did charge as attempting to provide material support to a foreign terrorist organization. That was a result of this. This investigation went on for over 2 years. And so, these types of tactics have been used again and again. Charlie, do you want to tell them about the case that we had out in California?
Most of our cases involved reverts in the lead up to this, but we're going to talk about the California case because it had significant aspects to political and religious speech. One of the things that stood out to us is we looked at it, and this will be a light in how you think about your organizations. The misinterpretation, we were successful during the trial in starting to correct the misinterpretations of political speech that the government, looking through that famous part, if you're a hammer, everything's a nail. So they saw all political speech as terrorism, supporting and all arguing for terrorism, and ignored other meanings or possibilities. And we saw an awful lot of that, especially somebody who was new to it asking religious questions and go, wait a second, they're just working through what would be permissible. He's not actually planning anything. But again, in part, we also wanted to say, I wanted to touch on this case because it involved Hamas. And it shows you how far the government's willing to press a statute. In that, after an awful lot of things had failed, they suggested, the undercover suggested, hey, we should give to somebody. Well, giving didn't sound as bad, and he went through and he looked for it, and he did ultimately come and say, well, Hamas is actually following the laws of war. They're not engaged. Israel's not following the laws of war. He was a former Marine, so he took issue with Israel's conduct, and but he didn't give to Hamas. And they said, oh, well, we want to. Can you tell us where the website is? And all he did after saying that, this part that Hamas seemed to be following the laws of war and Israel was not, was provide the link to the website. They charged that as material support. And that shows you how far this can be pushed in that attempt. That was a challenge, whether that was even a crime. Fortunately, in that case, we ended up with a mistrial, and then the government, after that, said, before the judge, who wanted to hear more facts, got to that ruling. We settled for non-terrorism charges. But it shows us in the part that even out in the Ninth Circuit, where they're likely to get the least sweat, how far the government is willing to push the statute, particularly when it came to Hamas. And so having them even in the chat talked about, et cetera, where he did not send money, didn't tell the individual to send money, and the individual merely asked for the link after he said they were pretty good, that was considered material. The government tried to charge that as material support. And that's a harbinger of things that we think are likely to come and why we need to really be careful on speech. So can we take us, say, to Sophia, just basically how they're going to approach this?
Yeah, so this is everything that they've been doing leading up to in the last 10, 15 years is very relevant and gives us an idea of the tactics they're using in these investigations. Counterterrorism investigations are not 2, 3, 6 month investigations like at the state level. They can go 2, 4, 5 years in our cases typically, and involve a lot of these undercovers and all of this. And we know from post October 7th, the FBI director at the time, Christopher Wray, was pointing out, talking about their priorities and saying that our most immediate concern has been that individuals or small groups will draw twisted inspiration from the events in the Middle East to carry out attacks here at home. Another former head of the FBI describing, locating potential terrorists as looking for a needle in a stack of needles, which is a nod really to this mass surveillance of Muslim, Palestinian, Arab, South Asian society and their speech, because they don't know who it is. They view all of us with suspicion. And then coming forward into now this, like we mentioned, the October 7th task force and this focus on rooting out terrorist financing and nonprofits. And so this, being aware of how these investigations work, how material support law has been operating in practice is important. Charlie, can you give us an example of the type of speech that can draw investigative attention in Gaza, for example, and how it passed?
Let's see, I don't know that we have the right slide on that one. Can we go back a slide, please?
That's the next one.
After that. Well, let's talk about, instead, I think I got a little off base there. I'm going to talk about, go back to the slide. Up till now, we've been talking about individuals and things like that. But Gaza and humanitarian aid has been the site of the largest material support terrorism case in U.S. history. And Gaza is unique. First off, Gaza is the only place where a designated terrorist organization was also elected as the government. Hamas won the general election in Gaza in 2005 and became part of the Abbas government. And so at that point, there's sufficient direction and control, because Hamas is in, that all governmental functions are suspect. Next slide, please. And there's this question, well, certainly they wouldn't prosecute humanitarian aid. I mean, most of this stuff is about violence, or they want to support the part. What about people just want to do? And then, the case is Holy Land, otherwise known as the United States versus Al-Mazin. And they were prosecuted for what all parties agreed was feeding children and providing other humanitarian aid. The government, if we can go to the next slide, we'll go through the timeline. The background, the Holy Land Foundation was a Texas-based charity, and it was providing humanitarian aid, and it was the largest at that time, back in the 90s and early 2000s. It was the largest Muslim charity in the United States. In December of 2001, following 9/11, although there was no links to 9/11, whatever, it was closed predominantly for buying weapons for Hamas. This was the allegation that they were directly supporting Hamas apart, and they shut them down. Now, a lot of the laws that they were able to do that with have been challenged, and they would not be able to similarly do what they did right after 9/11. But when we looked at it, because they were ultimately criminally charged, they were really the only organization involved in this that was criminally charged for material support. That started in 2003, and the case didn't actually end until 2008. First trial was a mistrial, but the second trial ended in convictions. And the sentences were incredibly harsh, 15 to 65 years for the board members and other participants. Now, what we learned was how long that investigation had been going on. During the course of the trial, they had been under investigation since the 1990s. There had been warrants under seals because terrorism is considered classified information. Unlike other warrants, no one knows that they're under surveillance. If I had been under a normal sneak and peek, or a Title III warrant to intercept or that part, I'd have to be notified of that. But under the Foreign Intelligence Surveillance Act and the individuals that they were being investigated for terrorism, they had no idea. So the first thing I can say to people is these investigations that Sophia runs very long. And then in 2002, they challenged their designations, and ultimately, they would have more likely succeeded 8 years later on challenging the designations. A criminal indictment came down and they're convicted. So, next slide. Let's talk about how that happened. The prosecution called 3 witnesses, primarily. Robert Miranda, Laura Burns, and an anonymous Israeli agent who was called as an expert witness. All of these tried to make that link that Hamas activists, there were 3 parts. One, that the HLF used Hamas activists to speak at its fundraising events, showing direct coordination with Hamas. This individual cross-examination was actually pretty part of it because the testimony shouldn't have been allowed. It was incredibly speculative. He admitted that the speakers were not listed on any terrorist website, and it was not illegal to have them as speakers. They just said sympathizers. What was a sympathizer? That's somebody who's posted something that was pro-Hamas. No tags or whatever, but that was argued for it. The next part, Laura Burns testified that there was a letter from the Zakat Committee as ours, and said that the HLF contacts with the committees were Hamas leaders. Again, ours could be people we know, or Palestinians, et cetera, like that. But they allowed her, Laura Burns had absolutely no expertise in the Middle East, but they allowed her to testify as to that. And lastly, the anonymous expert, the only time in American history that was permitted, testified that Hamas's funding comes primarily from international groups like HLF, and that the Zakat committees are all staffed by Hamas members. He said that the Israeli man found praising suicide bombers in the search of the Zakat committees, though they did not produce that information. If on its surface, that wouldn't be enough on the case. But here was the problem. Next slide. Underneath all of this was the atmosphere. We have found this is still the case. Jurors have an anti-Palestinian bias when it comes to terrorism prosecutions. That doesn't seem to persist in other cases, but it absolutely persists when you say Muslim and terrorist. So you do not start with the greatest jury. And the judge severely limited jury selection in the second one. They'd been more successful in the first trial. Board members, the next part that was really difficult on it was board members were associated with Hamas. That was the bit, I think, one of the most difficult parts of what made them attractive, was several of the Hamas board members had relatives who were in the leadership of Hamas. And that gave the appearance that there was a connection, even though they had chosen very different paths. Hamas, Holy Land had, prior to the designation, and even afterwards in some ways, expressed verbal and written political support of Hamas and its goals. They had things like "from the river to the sea" was on everything. which is also Hamas goal. And so they said they're linked together in the ideas of what they want to accomplish. The government argued that the zakat were under control. And these things combined, which was circumstantial evidence, the anonymous expert was believed. In retrospect, the absolute problem, and this is completely unfair because no one was doing it then, was the lack of the vetting of the zakat committees. It's unfair to say that. That wasn't standard operating practice, but it's become because, the Israeli agent, Laura Burns, and all those people, the defense attorneys really didn't have a way to combat that. There wasn't a real effort to say, hey, look, we're removing board members and family members who have any connection or might have an interest from these decisions. That we're vetting the zakat committee ourselves, not just relying on parts to say, no, there are no. And we went through all of the stuff, gathered information on them so that we are trying very much not to give to someone under control. So when it comes to terrorism, the only successful defenses, and we've had a couple of them, are positive defenses that say, hey, look, I have vetted them. They aren't who you say they are. Next slide.
All right. So based on our cases, does all of this mean anyone engaged in humanitarian aid can never criticize Israel or talk about what's happening on the ground? So, thank you, Charlie, for going through all of that. I think the Holy Land case is instructive. There have also been changes since then. All of the more recent cases that we talked about that we've had provide a lot of information that instructs sort of our speech, how it's looked at and assessed in the current climate. And this question really depends on each individual. At the beginning, Charlie mentioned every situation is fact specific to that individual or organization. And this is a risk tolerance question. It's a sliding scale. It depends on your background, your communications, associations, and your activities, specifically activities that are happening abroad. And the way that sliding scale operates essentially is individuals that do not have any ties to groups or people that they don't know in areas where there are designated foreign terrorist organizations. So, for example, individuals that are providing a lot of aid in Gaza to people that they don't know, smaller groups, not through vetted organizations. They have a very low risk tolerance for their political speech, because if their political speech is, approaching right up to the line, if their political speech is very pro-Hamas, pro-resistance, and it turns out that some of their aid has incidentally gone to somebody that is a member of a designated organization, that provides that circumstantial evidence of intent, right? This person supported them ideologically, with their protected speech, but then this criminal act occurred. And so that draws that link. But individuals that do not have any of these sort of foreign ties, right? And this can be ties on the ground. This can be ties in groups, right? There are a lot of chats, Telegram chats, Signal chats, other chats with individuals that are on the ground that are, it may be very obvious or somewhat obvious that they are linked to combatant activities on the ground. So those ties as well. But individuals that do not have any of that, their speech is focused on activism in the US, right? Protests, university speech, political speech, just domestically in the US. They have a higher risk tolerance and can have that more expanded speech. The purely prohibited speech, right? This is speech that incites violence. So these threats, specific harm threats that or inciting speech. And then also what we talked about at the beginning, speech that is not entirely independent of a designated organization. So those cases acting as a spokesperson or as a perceived spokesperson, right? Sharing direct news from on the ground, retweeting messages from designated organizations, repeating calls to action and things like that. That is approaching that prohibited problematic speech. That direction coordination doctrine that we're talking about, that wasn't fully articulated at the time of the Holy Land case. It has been now, it applies now But if you have concerns and questions about your speech and that line, it's not fully defined and it's different in each situation. So it's better getting advice in those cases. All right, that's a lot of information. Let's look at an example, Charlie.
Sure. In this part, we have an Instagram post that goes viral, and I have difficulty seeing. We have to start being more vocal about supporting the Palestinian resistance. The West strategically labels our resistance as terrorism to intimidate us from speaking out, but we will no longer be silent. We only fear Allah. Speak out on your support and resistance, okay, with a triangle. Now, Sophia, are there any concerns on that? That's just political speech. It's calling for somebody to just speak out, right? That's protected political speech.
Yeah, it's an interesting question. So we actually, this is almost an exact copy of an Instagram post that went viral that we saw lots of people liking, sharing, and it raised a few concerns, right? Again, for certain individuals, maybe a slightly lesser concern, for some, a huge concern. But this red triangle, what does a red triangle mean? Everyone has the same understanding of that, especially at the time that this was going around. This was a lot of the videos that Hamas was sharing when they were hitting Israeli targets, and they had the red arrow, identifying the target. And so this became the viral symbol online to sort of signify Hamas, the resistance, in kind of a celebratory or supportive way. And then this post, and we've seen a lot of these, actively calling for supporting the resistance, asking you to add the red triangle to your profile names, calling for active support, right? And so who it's concerning for depends on that individual. If you are part of a nonprofit and you are identifying GoFundMes and individuals on the ground in Gaza to actively send, resources to, this is extremely risky speech, right? This can suggest those issues can be raised with those individuals later. If you're just an activist, still it raises concerns because while it doesn't actively say Hamas, that was raised in a session we did, everyone understands who the resistance is. And so your other speech or other activities, this is the type of post we have seen initiate investigations. Just liking posts like this, we have seen in some of our cases at the very beginning of investigations. And so while it is not prohibited in and of itself, I wouldn't say it raises its own concerns for different individuals.
And we do that to show you on the part is that something that would seem to be most people to be legal, and the government may not charge that, but if they can get enough other stuff, they will, and it almost certainly bought an investigation, which may be still ongoing for all we know. So, what can nonprofit? Oh, this is yours, isn't it, Sophia?
Right. So what can nonprofits do to protect themselves from a biased investigation? We've thrown a lot of information at you, and it is concerning. Whenever Charlie and I talk about these topics, people tend to respond with panic or concern, worry, especially that this is a lot in the news now. But there are practical things to do, with this information. Education is a big part of it because it helps you sort of identify issues and red flag things, where to seek counsel. A couple of practical things can be adopting or updating your document retention policies so that you as an organization are maintaining a very clear record on what you did, what you intended when you provided certain aid or collected certain funds, and you can always show that in the future rather than leaving it to investigators to determine that later. So that's an important step, and the best and easiest FBI interviews and investigations Charlie and I have had is where we can show the financial records for every transaction in question, the pictures for what the money supported, and all of that. That's a very clear story to tell. Also reviewing all of the aid or funds that you have provided and your current programs for compliance with best practices that have been issued by the government for highly scrutinized issues like the sanctions regimes and material support. concerns, and also, in the case of congressional investigations, working with experienced counsel in those cases, even where it is voluntary. So let's talk about the vetting and recommended practices we advise nonprofits on. A big part of this that we do in conjunction with our nonprofit department, who's going to come on right after I talk about these, is working with nonprofits that are providing a lot of aid or services in areas where there are designated foreign terrorist organizations, like in Gaza, Syria, Yemen, Afghanistan, or sanctions concerns. And there are recommended best practices for that on anti-terrorist financing guidelines and what that looks like. It's fact-specific and different for every organization, right? It covers the money laundering aspect, fraud concerns, terrorist financing. A lot of it is about documentation and vetting. So, all of this was issued after the HLF case. They did not have these best practices available then, or these vetting recommendations then, but we have them now. So the next slide. A lot of this vetting looks like essentially first sending out, to all of your partners, major beneficiaries, vetting forms where you're collecting all of the relevant information, ID numbers, full names, pictures of IDs, and then running this information against the sanctions list, against the UN sanctions list, the OFAC sanctions list, and getting clearances from that, but then also looking up these individuals online, asking for their social media, looking at their speech, what's publicly known about that organization, that individual. That also has implications for you, and that is where the material support concern may come in, because just saying somebody wasn't on the public sanctions list, but then if all of their public social media is pictures of them, and we had one case of someone wearing a military uniform that could look like maybe a possible member of a designated terrorist organization. So reviewing all of that together is important in the vetting process, and then documenting all of that and retaining that documentation long enough so that you have it for as long as you need. Let's go to the next slide. There are also attestations. The documentation policy we've talked about, there are attestations as well. And so in addition to that, beneficiaries, partner organizations, having them state that they are not associated with or members of designated terrorist organizations, they have not provided material support or resources to anyone that has been on the sanctions list. These are attestations that you can include in your documentation, along with other tools that we have and that our nonprofit department has. Because even if you do everything right, you've done all of the vetting, you have all of the right policies, the government can still look to find other issues in this investigation with your 501c3, as they do in a lot of cases. Sana, can you talk about all of the work that you all do in the nonprofit department to prepare and protect nonprofits in these cases?
Yeah. So I kind of alluded to it earlier in our call that MLFA is really uniquely positioned in that our two departments, the nonprofit governance department and Sophia and Charlie, their department, we work really closely with nonprofit Muslim organizations. And so how it generally works is that we do kind of this internal screening. And so that is the focus of our department, where, in order to kind of really give these organizations the tools to be able to kind of prepare and protect themselves, we look at a variety of categories within the organization. So we look at, the state and federal compliance. We look at handbooks, policies, things like that. We look at governance, right? Like, how is the organization run? What is the relationship like between the board members, and what are their roles and responsibilities? Everything down to the meeting minutes of an organization, of these board meetings, and it's always seems like something really small, and a lot of organizations are like, oh, that's not a big deal, or they don't even think about doing it. Or properly documenting. But like Sophia mentioned, that documentation really can play a pivotal role in these cases. So we try to do our best to do what we're kind of calling preventative work, right? And doing that work on the front end, right? Keeping your documents in an orderly fashion, keeping things organized, like Sophia said, keeping receipts and photos, and not only having the policies and procedures is important, but also knowing how to follow them, making sure everyone is trained on them. And if you have a protocol for something, like making sure it's actually utilized when it needs to be utilized, things like that. We look at, financials. Sophia obviously talked about that as well, but looking at where the money is coming into the organization and how the money is leaving the organization. Is it one person who's signing the checks? Is it two people who are signing the checks? So we do a pretty thorough internal legal screening for organizations here at MLFA, and then we kind of cross collaborate with Sophia and Charlie when it comes to the OFAC and doing the vetting and sanctions searches and all of that. So we really, alhamdulillah, are able to provide this kind of comprehensive service to our Muslim nonprofits who, again, are doing work internationally and abroad, doing advocacy work and things like that. I don't know, Homa, if you wanted to add anything to that.
That was really comprehensive. I think you made the point where you have to have internal controls in place, meaning policies, and you have to actually implement those policies. Sophia had talked about document retention and keeping your meeting minutes. It's all about being able to prove that you were aware of the law and did your due diligence when it came to it, and you've documented the fact that you've done your due diligence, so that if you are ever subject to an investigation, you are able to actually show that you did what you were supposed to do. You vetted everybody you were supposed to vet. And then in addition to that, having a social media policy and training your employees and your volunteers on what that looks like, and how to be mindful of what they put out there.
I know we're over, but I'm certainly willing to stay for a few minutes and answer any general questions that we have. If somebody's been sitting there on a question and they'd like to ask it, I'm happy to stay in there and answer for a few periods of time. But we are over, and we'd certainly understand if people leave. But I, for one, and I know everybody else is willing to stay for a few minutes and answer any questions you might have.
We're also going to add our email addresses into the chat as well. So if there is a more specific question or fact-specific question, please email us or go to our website and fill out an intake form so we can get to your question. And then I will also switch it to the next slide. Did we have, there they are. There we go. Their email addresses right here on that last slide. So if anyone wants to take a screenshot or copy our email addresses down, we're happy to address your questions. Let's see if we have anything pop up in the chat. Okay, well, any final thoughts?
Yes, I'm going to leave with this. Guys, in part, it may have sounded like a lot. Please come to us to part. This is the basic bottom line. In following the common sense, is you need to be able to prove who you gave the money to, that you checked the people before you gave it to it, and that they bought humanitarian stuff with it. You need to be able to track the money in and track the money out. You need to do everything in a public-facing document, or certainly not something that's hiding something. See, we have the idea that, hey, look, we're going to protect with secure and encrypted. It doesn't. It gives the impression when we don't do these things that something's hiding. And that's the wrong way to look at it. I know that, yes, they should have to prove we're guilty, but that's not how it works. And actually, for a nonprofit that has the public trust, you ought to be able to show where the money came from. You don't have to reveal your donors, but we got the donors from these type of people, and we bought these things with it, or we sent it to these people. We had checked them, and we did the best. That's for coordination for everyone. And we're happy to help you do that. when hard questions come up. Number two on it is people look at the other part and say, hey, if the police or the FBI shows up and I don't talk to them immediately, people will think I'm guilty. Nope. If you talk to them immediately, they'll think you're foolish in this process. What you absolutely want at that point that the investigation starts, or you have wind that it's starting, you want counsel to assist you. And to sleep at night, you want to have a checkup and have people look over you to make sure that what you're doing is right, so that you have the courage and the ability to do absolutely critical work in Gaza.
Yes.
And that's it in a nutshell.
Yes. No, it really is. It really is. We'd also like to just, again, I know we're 10 minutes over now, so we're just going to leave with thank you so much for attending. I wanted to thank Ruhama, who's our back end person, who's helping us with the tech side. We couldn't have done it without her. Thank you to Charlie and Sophia for your time, and to Huma as well for all the work that we all put into these clients, our nonprofits and our individuals who are in difficult positions oftentimes. Also, the next one coming up, which will be number 3 of 4 in this webinar series, is on Thursday, July 10th. Please mark your calendars. Go to our website where the link is up there, the mlfa.org/upcoming events. That one is going to be protecting your charity, voluntary steps to comply with anti-terrorism laws. And then the following one, I'll go ahead and plug that as well. That's Wednesday, July 30th. And that one, we're really excited about. We're nerding out about it. It's a practical case analysis. We're going to apply sanctions and criminal compliance to a hypothetical client. We're going to put together something really cool for you all. And I hope that a lot of nonprofit leaders join in, community members, to see kind of what the process would actually look like. You saw a glimpse of like some of those screenshots for the sanctions list and things like that, but we'll get more in depth. There might be some screen sharing and just, kind of how we're going to go through that hypothetical client. But July 10th is the next one. And then July 30th is the one after that. And we are just really excited about this series. You can find them all on our YouTube channel as well. So if you didn't catch it now, or if any of your friends didn't catch it right now, you can find it on our YouTube channel as well. So with that, I will wrap it up. Thank you so much, everyone. Have a wonderful evening. Until next time.